Appreciate it. So I just want to say thank you to Openwest for hosting such a wonderful event, and I'm very happy to be here presenting today. Hopefully what I have to add is something that can maybe enlighten the understanding of the IP world in general and kind of what's out there. So when you're making strategic business decisions on branding your company and things that might be essential to maintaining your competitive advantage, these are things you think about, as well as balancing that with what you want to release to the general community. So there's often a balance between those things for a company. So I thought I'd start out a bit by giving a background, basically just go over UIs and then talk a little bit about what ways traditionally people use to protect their interfaces and why they do it. So your UI is your virtual front door, right? Your customers in your company know you by the interface that they see and the widgets that you provide them, the usability, the services, and that's all kind of channeled to the client through your portal or your user interface. So UIs are very recognizable elements that people can look at and say, oh, I know what that is. That's that company, or that's company B, or that's company C. So, when a company looks at presenting UI, a new emerging growth startup, for example, they'll put a lot of time and effort into figuring out what the interface should look like, what components you should have, whether you have kind of what's your color scheme, whether it's super simple, whether you have any unique elements on there that differentiate you from competitors. There's a whole host of things that go into analyzing user patterns, a lot of research done on user behavior and how you make users sticky to your site so they spend more time on your app, whether it's a desktop app or mobile app or whatever it may be. That costs a lot of money and it takes a lot of time to develop, and it's not a trivial thing, and that's all kind of in the effort to obtain a unique look and feel that's different from some of the other competitors that are out there, right? You have to kind of justify your existence. So what are the risks of not taking steps to protect yourself, especially from a UI perspective? Well, since your UI is very closely related to your brand and your company, if you don't take any steps to protect anything, eventually you can see erosion, sales erosion and customer erosion, because other competing services might implement the same exact thing that you have, and customers might think to themselves, I'm not going to bother to go there because I can find this here. So it's important to maintain your exclusivity, or that strategic piece that gives your business its strategic edge or the differentiator over your competition. Plus, UIs are pretty easily knocked off. It's not too tough to reverse engineer a UI. It's not too tough to kind of implement some of the functionality or features the UI provides. And as a result of that, you can end up with waking up one day and finding out your main competitor had just basically blanket copied what you have, not to the extent where they actually copied your code, but to the extent where they copied kind of the aesthetic and the appearance of it. And there's really not much that you can do about it if you haven't taken any steps to protect yourself. So what do you have in your arsenal? As open source people, we're very comfortable with copyright. There's a lot of different open source licenses out there that license content to all various different people, and that content can be software, it can be images, it can be kind of anything digital, really. This is what will protect you from somebody coming and actually copying your code, copying your graphics, and using those without your permission, or using those in a way that you don't endorse, which is important under a lot of different variations of licenses that are out there that are open. Trademarks. Well, what does a trademark do? A trademark is very different from copyright. Trademark protects your brand, protects your company. You think long and hard about a name that's unique and interesting, and you put a lot of money and effort behind the branding and marketing of the products as well as the company, and that's all protected by your trademark. So if somebody else tries to call their company by the same or a substantially similar name, you're not going to be too happy with that, and you're going to take measures to protect yourself. That's what a trademark is. Trade dress is kind of related to trademarks, but it's a little different. I like to use an example of a Coke bottle, right? Long time ago in the 1800s, the Coke bottle was design patented, right? The shape of the Coke bottle was kind of unique, and it was design patented. And over time, users who drank Coke, these consumers, began to recognize Coke by the shape of the Coke bottle. And so the Coke bottle became a symbol for Coca-Cola, even though it didn't necessarily have Coke's name on it. And that is an example of what trade dress is. It's a product like an iPhone. It becomes kind of ubiquitous. It becomes distinctive, has like this secondary meaning. You look at an iPhone, you don't have to see the Apple logo. You just kind of know it's an iPhone, and you just know it's Apple. That's an example of trade dress. Now, there's two at the bottom here are patents. There's lots of different kinds of patents. There's plant patents, there's design patents, and utility patents. And they all kind of have different functions. Design patents really protect the aesthetic of something, like a user interface, for example. The utility patent protects the utility or the function of whatever it is that you're trying to patent. And that's what most people kind of associate when they say the word patent. So here are kind of our 5 tranches of tools that we have that you can use to protect your UI and your brand.
Can you just distinguish a little bit more between trade dress, which you described as being difficult to establish, and the design and utility patents?
Sure, yeah, that's a good question. So trade dress and design patents have a lot of overlap. And what the difference is trade dress is difficult to acquire because the general public has to really associate a distinctive meaning with whatever the article is that you say has trade dress protection. So, say you have Shasta, they make drinks. Well, they have those 2-liter bottles, right? Well, you look at the 2-liter bottle, you don't think Shasta, right? But you look at a Coke bottle that has that unique shape, you think Coke. And the reason is because it has that distinctive extra secondary meaning. So you really have to acquire that secondary meaning to get trade dress. With a design patent, it doesn't matter. It can be boring and plain, doesn't have to be distinctive, it just has to be new and different. And if it's not interesting, that's not an inhibitor.
Have design and utility patents been around a long time, or have they sort of been created?
Yeah, they're enabled by the Constitution that was originally written. And they've been around since the United States has been around. Yep. So today's discussion is kind of touching on what you noted, is design patents. Not a whole lot of people know what they are, and what they do, and why they are. And so I thought I'd spend a little bit of time describing how they can be used to protect UIs, especially as it relates to your brand, and maybe distinctive things that you might want to consider from a perspective of protecting who you are as a company and things that might represent that. So what is a design? Well, it has to be new, has to be original, and it has to be ornamental. And that means it just has to protect the aesthetic. So a design patent doesn't protect how something functions at all. It really protects how something looks. And sometimes look and function can be interrelated. And you can get into this gray area, right? Like the end of a USB, right? End of a USB is functional, but it also has a certain aesthetic design. The Thunderbolt cable, it's functional, but the interface itself has a certain aesthetic. Car parts, the lenses on your car, designers spend hours and hours and hours making them look like a cat's eye, right? But they're functional. I mean, it's a lens. It has a light in it. It casts light onto the road as you're driving. So it has both of these kind of aspects to it. What the design patent protects is the look of the lens, if we're talking about a car. And the utility patent would protect how the lens works, how the light shines, that kind of thing. So the ornamental design is for something that's made by man. So you can't go out and design patent something that's in nature. You actually have to make it, create it. It can be virtual, it can be physical, but it has to be something that you actually make. So I threw up a bunch of examples of stuff that's been design patented. And some of these might surprise you, and some of these you maybe kind of expect. We touched on the Coke bottle here. Some other interesting examples are a tile layout. So if you have a very distinctive tile layout, if you're a contractor or you're a tile manufacturer, you come up with this cool way of laying tile, you can actually design patent the pattern. Here's a replacement part at the top. The look of that lens is design patentable. Fonts. You spend a lot of time and effort putting fonts together. A lot of creativity goes into making those. And you want to control how those are licensed. You want to control how those are used. This is a very common way is to obtain protection and then license it either openly or according to your own desires. UIs, so here we have Siri. The UI for Siri is something that's been design patented. Mac Pro, and I'm sure all of us have a lot of experience with those controllers. So some other examples, I've tagged these with the manufacturers. Very expensive watches. These are knocked off all the time and imported. So a very effective way to stop imports of counterfeits is to get design protection on the interface of the watch. Tesla, they've design patented the replacement parts for their car. So the rear door has a certain shape and look to it, and that's something that's been design patented. Rim, we have a case, we have icons that are probably very recognizable. Other replacement parts, fashion, accessories. It goes on, pretty much anything. So in a design patent, when you're writing a design patent, I'm not going to spend a whole lot of talking about this, but I just want to emphasize that the drawings are absolutely essential. The better your drawings are, and the more time you put into kind of thinking about your design and what the drawings are, the better your design patents be, and the more alternatives it gives you to change up your protection down the road should you need to do that. So drawings are key. They're absolutely essential. And in a general kind of, if I was to design patent this pointer here, and it's got a unique shape and whatever, in my design patent itself, I'd take kind of have every perspective in the design patent, top, bottom, left, right, front, back, and then maybe a side view that shows it in action to give some context. Well, with UIs, you don't really need to do that. I mean, it's really 2D for the most part. So you only end up having a few drawings, and normally in the design patents for that particular implementation. So who's out there getting design patents? And are people really interested in these things? Well, you'll notice that most of the names on here are very recognizable. There's a big mix. I mean, you have home products, you have heavy machinery, electronics, consumer devices, household products, you name it. There's pretty much everybody out there is creating something that has a design aesthetic to it, obtains design protection for their products they feel like are winners, that are really going to be out there and recognizable. So the general design filings over time, this goes back to 63. You can see we're definitely escalating up. They become more and more popular. And I figured it would be a lot more relevant if I showed kind of a segmentation of the UI-related design filings and how those are increasing over time. And I find it pretty interesting that, during this era we had a little bump, but since 2012, special as Apple and Samsung had their big, run-in with each other, design patent filings have gone up substantially since then, and I anticipate them continuing to do so. And that fight is nowhere near over, but you'll notice that two of the top filers in here are Samsung and Apple. So there you go. Advantages. So why design patents over utility patents and so on and so forth? Well, what I want to emphasize is none of these are alternatives to one another. All those 5 of those forms of protection we started off discussing are interrelated, and you can obtain all of them. And basically what you do by doing so is you differentiate your protection. It's kind of like your investment portfolio. You don't want just all one stock, right? You want to go in and you want to differentiate what you have, and that'll make strength in the differentiation. Well, it's the same thing here. If you have a product that has function and design, it's really wise to get protection on both the function and design, especially if that product's a winner. You know, it's something that's going to differentiate for you from kind of the rest of the world. So design patents relative to utility patents, and we'll make kind of this comparison. They're a lot quicker. They only take a year to 2 years mostly to get issued. Whereas if you file a regular patent, you could sit around for 3 or 4 years, and it could just take forever. So they're pretty quick. They're a lot less complex. There's only 7 drawings in the patent, a little bit of text, and that's it. There's nothing really else to it. They're a lot less expensive for that reason. It takes a lot less time to prepare them. And your general overall cost, you're probably looking at a budget between $4,000 and $5,000 versus $30,000 for a regular utility patent application. So there's a huge differentiation in cost. 85% are granted. They can complement other forms of protection like utility patent protection. They're easier to enforce, and they have some special nuances on the damages side where you can kind of get some extra money if you find an infringer. But I won't delve too deeply into that. So design patent nuances. They don't last as long as utility patents. 14-year term from issuance. You have 6 months. If you file your design, register your design in Europe, you have 6 months in the United States to get that filed here. So you have that 6-month right of priority to claim that earlier filing date if you want to. With the regular utility patent applications, it's a year, so it's a little different there. There is no such thing as a provisional application with a design. You just file your design. I don't know, for those of you who are familiar with utility patent protection, you can file what's called a provisional application, which is cheaper, kind of dump everything you want into it, and then 1 year later file the real application.
When you say a 6-month right of priority, is that the idea, if you put something out in the market, you have to file the design within X period of time, 6 months?
So that's the public disclosure piece. You still have a year grace period with the design patent from when you publicly disclose.
A brand new UI where it's for the first time coming into public domain.
That's right. Yep. And have a year to still file your design patent. But if you file another application somewhere else and you want that earlier date, you have to do it within 6 months to kind of relate it to that other application. So that's what the priority differs from public disclosure in that manner. And there's no kind of international treaty for filing designs, so you can't just file one and it kind of goes over everywhere in the world. You have to file in all the different jurisdictions separately. There is a treaty kind of under discussion, but it's not passed yet. Hasn't been adopted by the United States yet. So it's the last slide on the nuances of designs versus utilities. If you look over here in the right-hand column, you'll notice that 601,317 total applications were filed this year or last year, and of those, 35,077 were designs. So the lion's share are utilities, which protect the function. All right, with all that, I know that was a mouthful. With all that, what does that mean to me? I'm just a UI guy. I'm just trying to earn my money. Why do I care about this? And what I did is I aggregated a bunch of examples of other companies you would know and probably products that you use to show you some of the elements that you can consider for protection, especially as you're putting together a unique interface that might represent maybe a unique product or service that's just not out there, and you want protection for it. So I'll start with user selectable buttons. So here we have an example of, everybody should recognize the interface on the right, I'm assuming. Slide to unlock feature, which Apple introduced with their iPhone way back in 06, 07. This, when they released their phone, it was just something the world had never seen before. And all these features were very, very new at the time. Now, when you're looking at design patents, they date back to the date you filed them. So you kind of can't use hindsight, and you have to walk back in time to the date of filing to decide if at that timing this is something that was kind of new and different. And so if you walk back to 2006, 2007, and you look at the slide to unlock feature, that's something that's really cool. And so Apple kind of knew it, and so they filed for protection on pretty much all the aspects of their iPhone. And you'll see in 2 separate design applications, they kind of filed them differently. So on the top one, they actually used the actual icon as it looks, almost in a photo form. And this one, they wireframe it out. And what I want to do is just touch in why you see some stuff that's in these dotted lines and why you see some stuff that's in these solid lines. Well, in the design patent application, when you file it, whatever you put in solid lines, you're claiming as your design. Whatever you put in dotted lines is just contextual and doesn't actually represent your design at all. So it's not actually claimed. And so it's a lot broader to exclude some stuff that you don't think is really relevant to the specific design by carving out the stuff you don't want by using hash lines. So in the example on the right, what is covered is the nested boxes for the slide to unlock, and then on the top, the two boxes that enclose the clock and the status icons. That's your design. On the left here, you'll notice that everything's hash lined out except for the kind of the screen area and then the slide to unlock feature that's in the vertical orientation. One difference between the Apple version and the HTC version on the left here is Apple chose to hash out their arrow, so they didn't claim the arrow as part of their design, where HTC did. So all these subtleties matter because they have to be in an infringing product. So if somebody was to blanket copy HTC's slide to unlock feature, they would have to include the arrows.
So aren't these designs pretty easy to skirt around then? I mean, just like in this example here, if you've got a good creative designer, he goes, well, we'll make it go vertical instead of horizontal, we'll add some arrows, and bang, now it looks different.
Yep.
But can a utility patent actually protect the functionality and
Yes.
say, hey, you know what, this type of functionality is unique?
Yes. So that's a great question, and that's exactly what you do. The functionality of how the slide to unlock works would be covered by utility patent. But the design patent would cover the actual aesthetic. And I think what Apple was worried about is what was going out of the back door of the fab in China, not what was going out the front door. And so, they'd have all these kind of gray devices that come out the back and be sold on secondary markets, and in some cases get imported into various countries. And what you can do is you can take the design patent to the Trade Commission of the country and say, look, I have protection, and then they can enjoin the importation of the counterfeit product. And so that's what Apple's worried about. So you're right. This scope of protection here on the right and on the left are narrowed to the implementation that's actually been created. And I think that's appropriate. I think that's how patents should work. And I think the problems we have in the patent system today are because people are taking advantage of that, and they're trying to get overly broad protection for things they actually didn't make. But that's a very astute observation. So here is another example of Apple's. This covers the Popup key. So I'm sure you've all seen this on your own phones. As you depress a key, you can see kind of a blow up. This is really neat for its time, especially as it increased accuracy on the keyboard with touch interfaces, which were, I think, denigrated up to this point as not being something that was viable because of maybe the false positive errors you'd get in typing and the kind of unsatisfactory feeling you'd get in using the interface. So here's another example, a little more recent example of Microsoft Surface. This is their split thumb keyboard, so it's a pretty big device, and if you want to use your thumbs, you can split the keyboard and have the QWERTY keys on the right and left flanking the sides of the screen. And here's the actual product in its implementation. And as I toggle back and forth, you'll see that the design patent covers the keyboard itself. Now, it is important to note that a lot of these keys are hash-lined out. So really, the only thing they're claiming as their design is the top row of keys. So an infringing design would have to have the top row and then the center section of keys. So for those of you who love the PlayStation 4 and have an Xperia phone, you may see this. This is a virtual controller that you can use to control your PlayStation. And it's been designed patented by Sony. And it uses all their kind of iconic buttons. So this is a much broader example of Target's interface for their search functionality on their website. And if you look at how they've claimed they've left out pretty much the interface except for the bottom and top area of the menu bar, and then the actual search box itself with the text, both the all categories text and the search text included. So an infringing design would have to be kind of that small of a text box with the rounded corners, have to have that specific text, and it have to be spaced between the top and bottom of the menu bar accordingly. So this one is something that's a lot more broad. And a lot of you are probably looking at this and going, how in the hell do they get a design patent on something like this? I can't say I didn't ask that question myself, but.
So is it possible or probable that they have a utility patent associated with that? Like there's some even functionality in their search that...
It is, and it's also possible that this specific variation with the exact words that you're using wasn't out there, and it's something that gives them an additional advantage as they perceive it. Remember, the design is very limited to what is actually there, so you have to have the words, search, and all categories. So if you didn't want to infringe, just leave out the all categories or put in a different word, and you don't infringe.
A question on that: why would it even be worth it for them to do that if I can go in and put squares instead of round corners and change out the all categories and stuff, and then I'm fine?
That's a great question, and it all goes back to branding. They don't want competitor sites to look just like theirs, and that's really what it comes back to. So for them, it's worth it to spend $4,000 on a design patent so they have an extra layer of protection for the brand.
Wouldn't they want to be less specific, though?
Yeah, I don't know why the choice was made to put in all categories. Maybe that's what they had to do to amend in order to get the application allowed. It could have been a lot of prior art, which I'm assuming there was, and that might have been what they needed to get by the prior art. So Facebook. All of us have probably used this interface. If you notice on top, we have in solid lines kind of this big horizontal square, and then the arrangement of those three icons that are still in the user interface today. And this here is a separate design patent that covers the status update, and it's basically just the square boxes with these two icons included. And I'm sure Facebook was very interested in protecting their design from a lot of the knockoffs that are overseas. There's just gazillions of them. And what they can do is they can enjoin those service providers here in the States and obtain some protection for their own brand. To them, that's very important, especially as they're a global company. But so this is an example of a widget that they actually design patented, various different widget elements as well as a navigational object. Pop-ups. So here we have kind of a bookstore interface. We have a pop-up with a kind of a scroll indicator here that's on the horizontal. The pop-up has to have that thick border on it and kind of has to have sharp corners and everything else. But this gives you an idea of what's possible with respect to different design elements. Here's one by Sony. This is an in-game element. If you've played, on the PlayStation or whatever, there's lots and lots of these different icons in the game, and Sony, for some reason, felt like this is something that added a lot of value, so they protected it. Limited real estate drives a ton of different features and a lot of innovation these days. And as a UI designer, you're going to think of a lot of creative ways to display a lot of information simply and in a lightweight manner. So it's super accessible and it's powerful, but it doesn't feel cluttered. And there's a lot of design patents out there that really cover scrolling through information, access of information, hidden kind of sidebars with small indicators that show pullouts, on and on and on and on and on. And I think we're still in the infancy of that. I think that there's just a ton of innovation going on about that. I read a lot about, different thoughts about what you should show, what you shouldn't show, and how it affects stickiness of your app and user time on the app and stuff like that.
So
yes.
Wouldn't this be one that totally want to have a utility patent with it too, because that transitional effect is very much about how it works as well as how it looks, right?
Yeah, the difficulty here is there's just a lot of prior art on the UI utility side, and I think that you would probably bump into just a whole deluge of art out there that describes transitional effects. And so the advantage here is this is specific to their implementation. They might have this is an HTC app. It might be related to a specific app and experience they have on that they don't want copied across platforms.
And is there, in trademarks and other stuff, they sort of almost tranche your trademarks based on industries and spaces and stuff like that in order to make sure you're not just encroaching on everybody.
Mm-hmm.
Is there that same notion with these, or is it sort of everybody's in the same pool, and even if your app is built for one industry and another industry has a patent for it, those could totally mess you up?
So this would be relevant to anything within kind of the virtual UI space, and that would be its bounding.
Which is a pretty big space.
Pretty big space, yeah. That's right. For those of you who have Samsung phones and use the voice recognition on that, this icon might be familiar. This is basically just an animated icon that, as it hears your voice, kind of fluctuates up and down, and they covered that transitional effects. This application has a series of drawings in it that show kind of the progression from kind of full to empty. Apple guys, IDOC. This is the design patent that covers IDOC. And you'll notice that in the IDOC design patent, none of the icons themselves are covered. It's really the dock itself. So it doesn't really matter the arrangement of icons you have. And that was one way to kind of broaden the scope of the IDOC protection. All our Xbox fans out there probably recognize this interface. This is a design patent that covers kind of the user experience on the Xbox. And some more layout stuff. Across platforms, you'll see quite a bit of differences with respect to the design elements. Now, from a 50,000-foot point of view, these are all just arrays of icons on a UI, right? Not really that much different between them. But as you look at it from a specific designer's perspective, they all have their own aesthetics. So these icons here are different than those, which are different from those in size and in shape. There's different offsets that are claimed here. So we have this bottom dock for the static icons that are contained in a kind of a standalone container. On the RIM implementation on Apple, there isn't any sort of boundary that divides those, and in Samsung, they're just kind of all plopped in the same interface.
Sorry to keep asking
Yeah.
questions, but like with trademarks, the trademark has to end up in the marketplace, right?
Yes.
To file it, and is it the same with these? Otherwise, Apple could have said, well, let's do round ones, let's do square ones, and they try to think of all the sort of variations.
If they wanted to file 30 patent applications on all the different variations, I think that would be an exercise in diminishing returns, but they could do it. Yeah. All right, so some of you might be designing products for actual really cool hardware. Nest Labs, came on the scene a couple of years ago with a revolutionary product. It's really related to this whole Internet of Things conversation that's happening today. Nest Labs thermostat will predict your needs. As you turn up and down the heat, as you live in the home, it identifies when you're there and when you're not, gets used to your habits, and then automatically adjusts the thermostat, and they argue that it'll save you about 20% in your overall heating costs over time. And this is designed to be controlled remotely, so you can turn the heat up and down on your iPad if you're in Switzerland and your house is in Spanish Fork, Utah. It doesn't really matter. And it connects to your Wi-Fi. There's a lot of really cool features with it. The founder of this company was really frustrated with the experience in his house with a lot of the utility management, especially since it hadn't really changed in 50 years. It's been pretty much the same exact thing. And that was the driver behind it. So they wanted to create a very unique user experience. And as a result of that, there's a lot of digital aspects to this product, as well as physical aspects. So the physical design of this product is pretty cool, right? It's sleek, it's very recognizable, and they wanted to protect it so we don't have counterfeit products coming on the market that are basically copycats. So they have a design patent that covers the hardware shape of the product itself. They actually have several. And they also have a series of design patents that cover the UI. So this is the virtual interface that's displayed on the front of the Nest device. And you'll notice in each one of these different design patents, they hash line out different things so they can claim different things. So here on the left, we have the indicators that are patented. Here in the middle, we have kind of this top box that's a selector that's patented. And on the right, you have this timeline, this chronology of setting your schedule of when you want the heat to come on and off and dial in the properties of the thermostat. So that's an example of having design protection that covers both the physical and virtual aspects of the product. So enforcement, I'll run through these pretty quick because I think we're running out of time here. But this is a really interesting case study. Apple v. Samsung, tons of patents were asserted. The bottom line is basically there's about $1 billion judgment that was granted by the jury, awarded to Apple by the jury. In the mix of products, these are all the Samsung phones that were at issue in the patent suit. So there's a ton of phones, right? The jury had to go through every single one of the phones and map those phones to the patents and decide how much Apple got per phone. So we have lots of zeros at the top there. And you'll notice that for the design-only ones, there were several that got pretty huge awards. And then we had a bunch of mixed ones that also accounted for a substantial portion. And these are the design patents that were issued in the suit. And the judgment itself was about $500 million based on the design patents alone. So 4 design patents, $5,000 each, cost Apple about $20K. They got a $500 million judgment. So I think they got the return on investment on that one. So one interesting point here is Steve Jobs is named on the design patent of one of the main ones at issue. And this was way back in 2007 when this was filed. So this is the main design patent that was at issue. What was claimed? Based on our discussion on hash lines and solid lines, what does this design patent cover? Yeah, exactly right. So it covers the curvature of the face, right? And it covers the button. The back is not design patented. So here is another example. So this was filed based on a parent application. The parent application in that one, something very different was claimed. You'll notice the back itself was all claimed, as well as a lot of the parts on the side. If you compare those, front and back. So a lot more features in the parent were claimed. This is the parent. This is the one that was actually in the litigation. They probably weren't able to assert this patent because too much of the design was actually claimed in the design patent. Where in this one, the necessary elements to cover the infringing product was, and they got a substantial judgment for it. So I hope this has been informative. These are the takeaways with regard to design patents. They can be used to protect UIs. They're very powerful in that way, especially if it's something that's really related to your brand and the character of your company. It's something that should be considered. Often easier to enforce. They complement other IP, obtainable much more quickly for a lower cost, and they can protect the aesthetic elements of functional elements. I'm happy to answer any questions.
Where are you based out of?
So we're a shop that's in Salt Lake. We really provide a Silicon Valley experience to Salt Lake. Most of our clients are in the Bay Area, and we've been working with a lot of the new emerging growth companies here in Salt Lake as well. And our specialty is computer science and electrical engineering. We also do design patents related to those areas. So that's kind of our bread and butter.
So do you have to be a large Silicon Valley firm to be able to afford this type of protection?
No. And one of the reasons we're here in Salt Lake is we provide a lower overhead to our clients. And that's really one of the things we're proud of is we are pretty innovative in our fee structures. And, we really want businesses to succeed. So we try to align strategy with their business motives. We're not all about filing just a bunch of patents. It's really being very strategic about their IP protection, whether that's an open source license, whether that's protect some, open others up. It all depends on what's going to add the most value to the company and make the company successful. So that's really what we're about. Yeah, please.
Just thinking about the Apple versus Samsung stuff in the news. At what point is a UI just could be a patent generic enough that it's either not going to be accepted or maybe won't hold up in court or something? Because to me, it seems like a lot of these are just not being involved in patents a lot.
Yeah.
It would be very generic to me. It'd be like, or if it is something that every device maybe needs to have.
Yeah.
Does that make sense?
Oh, absolutely does. And that's a consideration, especially I worked as a developer for a long time and used a lot of open source products. And I love those products, and I contribute back to those products. But I'm also a businessman, and I understand the brand of my company is something that's extremely important. So you really have to balance what you open up. You can't give away the whole farm, right? You have to have some sort of strategic advantage that brings in the checks and makes your company run. And so from a general balance of kind of weighing of the factors side, I like to open up everything I can from a platform end. But when it comes to a branding end, I want to be very strategic on what I open up, because some of that might characterize my company, and some of that might give back to the community and allow the community to adopt a certain, maybe it's a design platform or whatever it may be. And so those are very important considerations, and they're not always easy, especially when you're talking to your board and your board's saying, what? You want to give away what? These are arguments that you really have to think through very carefully. So you can make a business case for it and also a community case for it. Yeah, please.
How does enforcement work for like UI stuff? You're giving examples like Apple and Samsung, billion-dollar companies.
Mm-hmm.
But if you're talking small and mid-cap companies and you're talking about user interface, how do you actually get damages for that? Like, oh, they copied our look. What is that infringement worth or going to cost them? Or,
Yep. So there's a lot of ways you can go about it. One, it gives you a negotiation chip. So if you have a competitor who's ripping you off, you're going to eventually have a discussion with that competitor. And if you have leverage, this gives you leverage. It gives you leverage at the table, and you can talk about it. You may not ever take action, but it is something more than nothing. So that's kind of the most basic use case. A more complex use case is you might actually have products that are coming in that are counterfeits. If you're in the product industry, it's not too hard to take that protection to the International Trade Commission and have the importation enjoined until it's settled out.
I'm thinking more of like SaaS companies.
Yeah.
You've got like an @task and then some other company that starts ripping off parts of their UI design
Yeah.
or something like that. I mean, how do they sit there and go, I mean, to a certain part you want them to just cease and desist and not infringe upon the look and, utility or functionality of the design.
Yeah.
But if they're like, hey, sue us, what is the, I mean, do you have any examples of case law
Sure.
where that stuff?
I probably deal with this 20 or 30 times a year. So it's something that's extremely common. And it's a business decision. You really have to have the stomach for it, and it's a headache. I don't think there's any other way to describe it. But it's a headache regardless if you have protection or not. And if you have protection, you have leverage. If you don't, you don't. And so if you're smart, even if you go out and use it like a whip, you use it like a shield, it gives you a very strategic advantage, and it gives you options. And so that's really the takeaway. So you can decide to do nothing, and that might be a great decision. You can decide to just, forego the protection, and that's definitely a viable option. But there's all these different variables that go into the equation of making the ultimate decision, and it's never an easy one. I can't give it any better answer than that because it's just too complex. Well, thank you again, everybody, for your time. I've really enjoyed it.